Coke-Wallis into Institute of Chartered Accountants in England and Wales.
Yes, Mr. Jones, having considered the written submissions, the Court's decided to admit the additional evidence.
Please, my Lord, I appear together with my learned friend Mr. Joseph Curl on behalf of the appellants, the Honourable Michael Beloff, assisted by Miss Catherine Callaghan, appears for the respondents. My Lords, I propose to, in fact, I think it's best put this way. I will be speaking, I would imagine, for no more than 1 hour. Mr. Curl will then address you for something of a similar period, particularly focusing on the difference between the conviction complaint and the conduct complaint, as it's become known as, and then I shall continue with our submissions, and I would imagine that we will certainly be finished, if not the end of the morning, certainly only half an hour to 45 minutes into the afternoon.
Yes, thank you.
My Lord, the ancient doctrine, nemo debet bis vexaris, pro una et idem causa, nobody should be vexed twice in the same matter, is an ancient maxim that is not only alive and well, but it's seen healthy developments over the past several hundred years. My Lord, it is a fundamental rule, and in our submission, it's one that should not be disturbed unless there are proper and acceptable reasons for doing so, and of course recognised and enforced by law. My Lord, it's our submission, it's our case, that this is strictly a res judicata matter, in that the first complaint that was brought was identical to the second, in that both referred to, or effectively, were in respect of the conduct that underlined the breach of the direction given by the Jersey Financial Services Commission. My Lord, if we are wrong on that, then we move to the second position, where we say it is an abusive process for the Institute to bring the second set of proceedings. We, of course, will be relying heavily on the case of Johnson Gore Wood. The main point that we will be making from that is that in considering whether one could and should have brought the matters that are brought in the second set of proceedings, if they should have been brought in the first, one must take, and we say that the authorities, all of the authorities, point to this fundamental point, an important point, that everything is taken from a retrospective point of view. One looks at all of the circumstances that exists at the time of the bringing of the second action, and then in the consideration of those circumstances, one then looks backwards to see whether one should have brought those matters on the first occasion in respect of the first complaint. My Lord, the third position, we say we don't go that far, but the often quoted words of Viscount Birkenhead, F.E. Smith, as he's often known, then would apply. The words, case of Rutherford, where the Viscount said it's even better that some slight degree of injustice should be done in an individual case than that the court should abandon the sure anchorage of a dependable rule. That dependable rule in the context of this case, my lords, is the nemo debet bis vexari maxim that I referred to at the outset. My Lord,
What's
in
the
our-
difference between disciplinary proceedings and ordinary proceedings, so far as the application of these rules is concerned?
My Lord, I'm sorry.
What is the difference between disciplinary proceedings and ordinary proceedings, so far as the application of these rules is concerned, if any?
My Lord, the disciplinary proceedings are those that are set out in the bylaws.
Yes,
Of course.
yes, I appreciate that. My question relates to how these rules applied differently as regards actions, ordinary civil actions and disciplinary proceedings.
My Lord, no, not at all. We say that they are between themselves, much themselves. In fact, my Lord, I can take that point now, is that what we say in the framework of res judicata, that res judicata is in fact expressed as autrefois acquit within the criminal, or manifested in criminal proceedings under the rule of autrefois. Res judicata is reflected in the civil proceedings with the same principle of res judicata. The principles that are, or that the disciplinary rules and proceedings, we say, are applicable to the res judicata aspect, although it's only the principles that apply. We do not say that the autrefois acquit principle applies, although we say there's very little difference between the, in fact there is no difference in effect between the rules of autrefois and the principle of res judicata. But when applying it to disciplinary proceedings, we say that the correct principle, the correct badge, in fact would be res judicata. But as between the various jurisdictions, and that includes the disciplinary restrictions, the maxim, whether one is looking at autrefois or whether one is looking at res judicata, we say that they apply equally. We're looking at the principles rather than the badge. My Lord, following that point further, we say that the Institute, and in fact all professional disciplinary tribunals, they do not enjoy a special place. They are all prone to the oppression that's applicable here, that they should not be allowed to bring a second action when the first action was either the same or it is an abusive process to do so. They do not enjoy a special environment or a special jurisdiction. It applies. We accept, and there never has been any doubt, as far as we are concerned, that the professional bodies, of course, play a very important role in ensuring that there is compliance at a very high standard. Compliance is expected by their membership, but that in itself, my Lord, does not put them into a special position where the principles of res judicata or autrefois apply. In this particular case, and I don't think there's any need to go into the facts of this case in detail, but it's important, and I would invite my lords to look at the judgment of Mr. Justice Owen in the Administrative Court. There, with respect to Mr. Justice Owen, he sets out very clearly and concisely our position and the position that upon which we develop our submissions. My Lord, that's found in the core bundle. Core bundle, appendix 6, tab 6, my Lord, I'm sorry, and then sub
sub 4.
Four, my lord. Helpfully, the learned judge sets out the disciplinary bylaws at paragraph 12. He makes reference to bylaw 4. Bylaw 4.1a is the enabling provision. This, we say, is the charge. This is the basis of the complaint.
So which is 4.1a?
4.1a, my lord, is at paragraph 12.
My lord, you will see that both 4 and 7 have unfortunately been omitted in paragraph 12. So you have to write in 4 after disciplinary action, and then under proof of certain matters, 7 before 1.
Thank you, my lord. Thank you. My learned friend, Mr. Cole, will in fact be going to the actual bylaws later. But here, Mr. Justice Owen extracts the relevant words: liability of members or provisional members to disciplinary action. A member or provisional member shall be liable to disciplinary action under these bylaws in any of the following cases, whether or not he was a member or provisional member at the time of the occurrence giving rise to that liability. And the liability arises, A tells us, if, in the course of carrying out professional work or otherwise, he has committed any act or default likely to bring discredit upon himself, the institute, or the profession of accountancy. My lord, that is something that one should focus on in my respectful submission. That, my lord, is identifies the conduct that gives rise to the liability. The conduct, my lord, when applying it to the facts, was the breach of the direction given by the Jersey Financial Services Commission, that direction being not to remove documents. That, my lord, we say is the act or default. I stress it, my lord, because we say the act or default is, and I repeat, the breach of the direction. The proof of that act or default, once disciplinary action has been commenced and brought before the disciplinary tribunal, is found at 7, headed Proof of Certain Matters. 7.1a, the fact that a member firm or provisional firm has, before a court of competent jurisdiction, pleaded guilty to or been found guilty of an indictable offence, or before such a court outside England and Wales has pleaded guilty to or been found guilty of an offence corresponding to one which is indictable in England and Wales, shall, for the purposes of these bylaws, be conclusive evidence of the commission by him of such an act or default. My lord, what it's saying there is that if there is an equivalent offence here for the offence for which Mr. Coke-Wallis was found guilty of, then that's conclusive evidence of, and we go back to 4a, the act or default. And then in the alternative, if there isn't a conviction that's equivalent, or if there's an offence that is not equivalent to any corresponding one here in the jurisdiction of England and Wales, an indictable offence, then one moves on, or one can move on, to the provision at 7.1.3, where a finding of fact in any civil or criminal proceedings before a court of competent jurisdiction.
Would civil proceedings include disciplinary proceedings?
My lord, yes.
Within subsection 7.3b.
It wouldn't be within the court of competent jurisdiction.
My lord, we say that it actually doesn't arise in the proceedings.
No, I wasn't asking that. I was
But-
asking what the answer to the question.
But my lord, in my submission it does.
For a court of competent jurisdiction, is that right?
My lord, yes. And again, in our respectful submission, although there may be some debate over this point, that a disciplinary tribunal would be a court of a competent jurisdiction. But of course that is not what becomes a live issue here. What this is referring to is any other civil or criminal court where proceedings have developed, and proceedings have been ongoing, resulting in a decision one way or the other, conviction or acquittal. The tribunal is entitled to consider the finding of any facts within such a trial to be...
But I was wondering, because if you look at tab 11 of the main bundle, the court, we have the record of the decision the first time round, I think,
Oh, yes.
don't we? Which includes, well, might arguably include such a finding of fact in the last paragraph.
The last
Namely, they noted that it was alleged and not disputed by the defendant that he was caught by the police removing from the jurisdiction of the Jersey authorities original documents and records concealed in the back of his car in breach of this agreement.
My lord, yes.
Now, why is that not a finding of fact within the meaning of section 7(3)(b? Possibly because it's not a civil proceeding, but...
I mean, haven't we got to look at the bylaws as a whole? I mean, I haven't gone through them in detail, but there must be provisions in the bylaws providing for the tribunal, and I would imagine that if we look at that, those provisions, and also have regard to 7(3)(b, it's likely that 7(3)(b is not talking about decisions of tribunals.
My lord, it is, in my respectful submission, that is absolutely right, because the purpose of those bylaws is to establish proof that will allow a decision to be made in respect of whether there has been an act or default under bylaw 4. And what is envisaged there, as one considers the rules, and it's consistent with the drafting of the rules in respect of all professional bodies, as I understand it, is that they are looking at any proceedings that have taken place in a court of law.
So civil proceedings does not include disciplinary proceedings, whereas I thought, when I asked you the question a few minutes ago, you said it did include them. But I now understand you say it didn't include them. Is that right?
My lord, I certainly wasn't seeking to mislead my lordships. What I am saying is that when one looks at this from afar, and generally, that civil proceedings, we would say, could include the findings of a disciplinary tribunal. In the context of the rules, a strict understanding of the rules, then it wouldn't be referring to disciplinary.
Right, thank you.
Good. These other professional bodies. Look at 4G and 5.
The issue then arose as to whether they were the same or not, and I pick up the point, if I may, from issue 1. This is on page 23. That's external numbering. says there, Mr. Jones, who appeared for the claimant, submitted that the relevant bylaws are clear and unequivocal. Bylaw 4.1 gives rise to liability, whereas Bylaw 7 has a purely evidential function. Under 4.1, a member will be liable to disciplinary action if, inter alia, he has committed any discreditable act or default. Bylaw 7 provides for the proof of such discreditable conduct. Under 7.1, the fact of conviction is conclusive evidence of the commission by him of such an act or default, as is mentioned in Bylaw 4.1. He argues that...
Why are you reading this?
My Lord, what we're saying is here is that these were the findings. In fact, he moves on. The reason we're looking is that he concisely accepts the submissions made of exactly what 4.1 does, and that Rule 7 is there to provide the evidence in respect of the act or default. It is the Institute's point and position that the act or default is in fact the conviction. We say that that cannot be the case, and indeed Mr. Justice Owen expresses the point quite clearly at paragraph 30, where he says, in my judgment, referring to the bylaws, they are clear and unambiguous. Under 7.1, a conviction is conclusive evidence of the commission of an act or default amounting to discreditable conduct within the meaning of 4.1a. It does not follow that the conviction is itself the relevant act or default. To construe it as having that effect is to stretch the natural meaning of the words beyond breaking.
Did the Court of Appeal agree with that?
My Lord, it didn't disagree with it.
Didn't disagree. So you're holding that point at the moment.
My Lord?
You're holding that point.
My Lord,
at the
I'm
moment.
holding that point, yes. Which, of course, takes us on. One then steps back, and we will look at this in a moment. One looks at the conviction. The conviction, of course, doesn't stand alone. A conviction doesn't exist in vacuum. It's there for a reason. There has to be some conduct. The conduct, we go back, was the breach of the directive. When then one looks at the conduct complaint, the conduct that is now relied upon, of course, was the very same conduct that underpinned the conviction. And so we are saying it is same. It is the same. This is cause of action estoppel, and that is the end of the matter. When one looks, my Lord, at the two judgments, for want of a better word, the record of the decision, both in respect of the first complaint, the conviction complaint, and in respect of the conduct complaint, they are identical. My Lord, may I just make reference to them? Looks at page, at divider 9, page 85.
What is it that you are submitting is identical?
What I'm submitting is identical are the two complaints, my Lord. What has become known as the conviction complaint, which we find set out at tab 9, and the conduct complaint, which is set out at tab 12. The conviction complaint, of course, was dismissed. It was dismissed because there was no law, no offence here that was equivalent to that of the indictable offence for which the appellant was convicted. At divider 9, I needn't read through, but one can see the offence at 4.1a, and then it sets out what he did. The summary of the complaint conviction, the circumstances giving rise to it. At paragraph 6, paragraph 7, the concern and fear which gave rise to the direction. Paragraph 8, the discovery of the documents. And then the representations.
I mean, you simply say this, don't you, that if you look at the first part of each complaint, it's identical. Paragraph 4.1a, allegation, is identical in the two complaints. And if you look at the substance of it, that's identical as well, because the particulars of the complaint are failure to comply with the direction issued by the Jersey Financial Services Commission. So that the particulars of the complaint, the actual complaints, the formulation of the breach of the bylaw is in identical terms, and secondly, the particulars are identical as well. Because the complaint, the conviction wouldn't be sufficient by itself. It's the failure to comply with the direction, which is the criminality. You say they're identical in the same case. This in criminal terms would be autrefois, convict or acquit, and in civil or other terms, it would be an estoppel.
My Lord, yes.
Per rem judicatum.
My Lord.
And that's it in a nutshell, isn't it?
That is it in a nutshell, my Lord. And that nutshell, if I may take it further, is firm, it's closed, it's complete, and we need not go further. If we do need to go further, then of course we consider abuse of process.
Do you say that in the conviction complaint, tab 9, that the words "was convicted upon indictment at the Royal Court of Justice on the 16th September" were unnecessary? That they were unnecessary for the formulation of the complaint?
My Lord, but we do, yes.
Page 84, well, at the beginning.
Because this was merely a mode of proving the breach of 4.1a, and you don't have to set out the evidence by which you seek, by which in the complaint, you don't have to set out the evidence by which you seek to prove the charge.
My Lord, that is correct. That is right. And if I can take it one step further, the barrister that was working for and acting on behalf of the Institute, Miss Tracy Owen, she sets out in her affidavits within the bundle why she took this route. And to use her words, it was a shortcut.
Yes.
And of course, that's quite right, and that's quite appropriate.
Turned out to be a cul-de-sac.
My Lord, yes.
But I mean, you say that if you look at the particulars, as my Lord Dyson, John Dyson says, page 85, or I have it at tab 9, really it ought to, the words "was convicted upon" down to 2003 are irrelevant, because they aren't part of the particulars of the offence. And so it should read "in that he failed to comply with the direction." And that is the identical complaint which they're now seeking to advance.
My Lord, yes. That's exactly it.
And assuming that the principles apply, of course they may be different in regulatory proceedings, that's one possible point. Or it might be said to be a technicality. It is also said on the other side that there was no determination on the merits. There's another point there. But subject to those 2 points, you say they're identical.
My Lord, I do. Whilst we are at this part of the bundle, it may be appropriate to consider just what took place to show that there was a determination on the merits in our submission, and that is found when one considers the transcript at 9, 10, I apologise. Tab 10, this is the record of the proceedings. And this, my Lord, certainly won't be going through all of this, but the first 4 pages discusses the documents that were put before the tribunal. And of course, it's right to say that although Mr. Coke-Wallis was not in attendance on that occasion or represented, he made written representations, and those written representations and submissions were considered. One of those, or one raft of those submissions, was that there was no equivalent offence with England and Wales. Notwithstanding that, the tribunal proceeded.
Well, we have a summary of their findings, don't we, at tab 11?
My lord, we do. In fact, that sets out quite clearly the record of the decision. But, my lord, if I may, just consider how this was a true dismissal on the merits. When one considers taking it up from internal numbering number 8, external 96, the legal assessor then sets out the complaint, and then the legal advisor, Ms. Pato, she then addressed the court on the facts of the case. She refers at page 9 to the transcript from the Court of Appeal. She refers to the facts, etc., that give rise to the conviction. And then, whilst Ms. Pato opens up by saying that she is unsure as to whether there is a equivalent or comparable offence in England and Wales, at the end of her submissions, at page 10, simply said there that you, talking to the investigation committee, or the investigation committee say without more you should find the complaint proven. The legal assessor then raises the question of corresponding offence. Miss Pato then puts forward extensive submissions, I would say, my lord. She seeks to rely on section 165, 173, 177 of the Financial Services and Markets Act, but without much success. And then at 12, after submitting that 165 and 171 might apply, halfway down page 12, Miss Pato then says, "I'm sorry, I don't understand why you are looking for something that corresponds, because I believe that it does correspond." The legal assessor doesn't leave it there, and they go on to consider more about section 165 and 177 when a final attempt is made. But then, after a consideration of the facts, a consideration of the law, it is decided that there was not a corresponding offence. And that brief finding is found at page 14. And of course we have the full record of decision, which we say is evidence that this was a decision on the merits. It wasn't dismissed for any inadvertence. It wasn't a technical dismissal. It was a consideration of the merits, dismissed on the merits. And my lord...
Is it right that the only basis upon which the charge could have been held to be made out was that there was an equivalent indictable offence? Yes. I.e., it wasn't open to the tribunal to say, well, although there's no indictable offence, this is an absolutely disgraceful piece of behaviour, and we're satisfied that the underlying conduct complained of falls within the prescribed description.
My lord, it would have been open to the disciplinary committee to have come to that conclusion, but before jumping to that, it would have, the appropriate way forward would have been for the Institute to have put before the tribunal all of the evidence
Yes.
that was available before the court.
I mean, it's right, isn't it? It looks to me as though Mr. Shaw, rightly or wrongly, was under the impression that there was only one issue before the tribunal, which was whether there was an alternative indictable offence.
My lord, that really should have been the only issue, but it moved beyond that.
A fair reading of what's described as the conviction complaint is, in fact, that it was a conduct complaint.
Yep.
My lord, yes. That was the effect of it, my lord.
And this decision, in fact, is almost perverse.
My lord, yes. But of course,
I think it seems to me it's been rather a tactical error to describe it as a conviction complaint at all. Because your whole point is that they're the same complaint and that they're only a conduct complaint. Both complaints are a conduct complaint.
my lord,
what you
these terms...
And indeed, so when they say, and put it in writing on page 105, accordingly the tribunal dismissed the complaints. The complaint they were dismissing was the alleged breach of 4.1a for failing to comply with the direction ... And therefore you say there, well, what more do you want?
Yes.
It's the word however that I had in mind of the decision. The decision having said that this is not the sort of conduct that's to be expected of a member of this institute. However, the tribunal had to be satisfied that the offence corresponded to an indictable offence in England and Wales. So you would say that was a misconception, was it? He didn't have to be satisfied.
My lord, at that stage, no, my lord, not at all. I'm sorry if I gave that impression. At that stage,
yes.
The way that it was presented before the disciplinary tribunal, they had to be satisfied. But of course, it was a matter for the Institute to decide how they presented the case. They decided, after consideration, this is not, and we make great store by this. This was not a slip, this was not inadvertence, this was after careful consideration and deliberation as to whether there was an equivalent offence. And they, in fact, we can turn to it, although I think I can safely refer to the quote, where Miss Tracy Owen, in referring to why they moved ahead, which shows it was not an oversight, was not inadvertence, used the word that this was legitimate, subject of legitimate debate as to whether this was equivalent or not. And when one considers the way that the Institute presented their case before the tribunal, it can be seen that there truly he was in the peril of jeopardy, in that there may well have been tribunals that may have been satisfied that this was a comparable offence. It just so happened, and rightly so in our submission, that committee took the view that no, on the evidence that you have put before us, there is no equivalent offence. But my lord,
what is ironic, though, is that if you look at tab 11, at page 105, in the last paragraph, they said, they noted, this is the tribunal, that it was alleged, and not disputed by the defendant, that jointly with his wife, he was caught by the police removing from the jurisdiction of the Jersey authorities original documents and records concealed in the back of his car in breach of this requirement. Well, there you have a clear admission of the allegations against the, generate on the face of this record, an admission of the facts which gave rise to the underlying complaint. So why they couldn't say, well, he's admitted the underlying facts, I don't know, but it is true to say they didn't.
There seems to be a complete misunderstanding, but the double criminality requirement doesn't make any sense if the foreign conviction is just evidence of the matters complained of. Why is there a double criminality requirement?
my lord, it's just the way the rules have been drafted.
Yes, well, it looks as if the drafter of that part thought that a conviction would be itself relevant conduct, but it isn't under the rules.
My lord, yes, and the point was taken before the administrative court and clearly answered by Mr. Justice Owen that if the Institute intended for a conviction to stand alone as an act or default, they should have said so. But it's quite clear that the rules do not do that, and Mr. Justice Owen was quick to point that out, that it does not, notwithstanding the fact that there are other disciplinary bodies, not many, but there are one or two others where a conviction does stand.
Yes,
One
I
of
suppose an
which-
alternative reading of 7.1 is that a conviction could be itself an act, a relevant act, bringing disrepute, bringing discredit.
Well, that was the reading of the Court of Appeal.
Yeah.
Whereas it acts says that it shall be conclusive evidence of the commission.
It's
But,
not
but it's only conclusive evidence if you can prove it. If you can prove a conviction which falls within subsection 1. And this was a conviction which didn't fall within subsection 1 because it didn't satisfy the bit in brackets.
Anyway, a conviction isn't an act. At least it's not an act of the person convicted.
My Lord, no.
Yes, well, anyway, the picture is pretty clear.
My Lord, yes. Perhaps we can proceed now to the
The law.
law.
Yes, good.
Law, again, with respect, my Lord, I say the law is clear. Perhaps I can take it from this point that the doctrine of, as set out in Connolly and the dicta of Lord Devlin, the doctrine of res judicata, occupies the same place in the civil law as the doctrine of autrefois does in the criminal. Lord, that is a uncontroversial proposition and one upon which we develop our submissions. Of course, the overriding or the overarching principle which res judicata attaches to is the nemo debat bis vexare maxim that we made reference to at the outset. My Lord, I will be considering and picking up my submissions, might assist the court from our case statement. And page 4 of that case statement, Lord, perhaps the appropriate way forward before I get on to res judicata is just to briefly deal with autrefois. We say that autrefois applies within or is manifested within the criminal proceedings, but it is of note that Lord Bridge, in the case of Harry Lee Wee, a case that is very similar to this particular case, my lords. The case is briefly this, and we can turn to it if necessary. The brief facts of that case was that the solicitor had been charged with conduct that was discreditable on the basis that monies had been removed from the client account, and rather than reporting that offence to the Law Society, it was covered up in an attempt for the solicitor to repay the money back to the client account. 2 points flowed from that. One, that it was discreditable conduct as far as the Law Society was concerned, and a complaint was laid and found, and then subsequently there was a conviction. The Harry Lee Wee was subjected to 2 years disbarment or disqualification under the conduct, and then under the conviction, the same thing again happened to him, where he was disqualified yet again for another 2 years. My Lord, we can pick up the points at tab 12, if I may, of the bundles, where Lord Bridge makes a particular point that we say is relevant to these proceedings. It's at page 362.
It's 368, isn't it?
368, yes. At paragraph D, what was required to translate the language appropriate to describe this misconduct by the solicitor into language which rendered him guilty of offences under section 213 of the Penal Code, that he accepted restitution of property to himself in consideration of his concealing of an offence, concealing an offence. The labels to describe the two aspects of professional misconduct differ, falling as they do under paragraphs A and B of section 84 of the Legal Profession Act. It was argued before the Law Society that the added element of a bargain between the parties was an essential element of the criminal offence, but not of the misconduct alleged in the delay. That, they say, was the, albeit superficial, but nevertheless was the determining factor. I read on, this appears to their lordships a technicality without merit. My lord, I refer to and rely on the next paragraph. No one, says Lord Bridge, would dispute that the doctrine of autrefois convict and acquit is applicable to disciplinary proceedings.
Well, that's no one except the respondent in this case. Well, that's not the position of the respondents. I mean, the respondents say that's wrong.
My lord, they do.
And you accept that?
I thought you accepted that too.
My lord, what we say is that the principle of autrefois acquit does apply. The label does not. So it's right to say, strictly speaking, that autrefois acquit does not apply, only applies to criminal proceedings. When one moves into disciplinary proceedings, we say res judicata applies.
Well,
but nevertheless,
I think that's common ground.
my lord said, yeah. The only point I'm making here, my lord, is that it's the principles that apply, and to understand why Lord Bridge would have made such a statement in the context of what is being said now, is that it had very strong criminal undertones when one considers that whole case, and no doubt the reason why autrefois is referred there. But, my lord, it's the principles that we extract. And when one considers the situation of Harry Lee Wee, and we consider the present case, there is little to any difference, and the principles we say must apply.
Yes, Mr. Jones, if the tribunal had found that the conviction in Jersey was a conviction equivalent to the offence of disposing of a document which he knows or suspects would be relevant to an investigation, which is the English offence, if that had been found, and your client had then received some disciplinary sanction, I doubt very much whether Mr. Beloff would suggest that it would have been open to the Institute to bring further proceedings against him, disciplinary proceedings, based on the same conduct.
My lord, that must be right.
That is accepted. Indeed, yes. I think it's in our printed case.
Yes.
It'd be no purpose served.
My lord, that must be right. But
so whether you would say that was autrefois convict or not is perhaps of no great moment. It would have been a bar.
It would have been perjury judgment. My lord, no. But of course, that's not what happened.
No.
What is the proposition we're to look at this case for that you want us particularly to apply?
My Lord, the main reason was to demonstrate the similarity between Harry Lee Wee and the case that's before your Lordships today, and that the principles of autrefois apply to disciplinary proceedings. My Lord, the principles that apply, we say, in this case, are those principles or those ingredients under res judicata. Mr. Justice Oliver, in the case of Midland Bank Trust v. Green, it's at tab 24, although I'm not inviting my Lordships to look at it at the moment, but what that does is that it sets out how the Court of Appeal approved the ingredients set out in the book of Spencer, Bower and Handley, a leading authority on the subject of res judicata. That is at tab 83 of the bundle. But the ingredients that we have to show to fall fairly and squarely within the principle of res judicata is that, one, the decision was judicial in its relevant sense. Two, the decision was in fact pronounced, that the tribunal had jurisdiction over the parties and the subject matter. The decision was final on the merits. Sorry, it was final. It was on the merits. It determined a question raised in the later litigation, and the parties are the same. My Lords, taking the first point, we have the case of, or the question, whether it was judicial in the relevant sense. What is important here is to decide whether or not there is a jurisdiction. My Lord.
But which of these points are in issue?
My Lord,
For myself, it seems to me the only arguable question mark is on the merits. Was this a decision on the merits? It was an attempt to take an evidentiary shortcut. Had it been taken as a preliminary issue, I don't think anyone would have suggested it was a final decision on the merits.
My Lord, that's how on reading the respondent's case, is how I see it, although it isn't so clear. But my Lord, I think it's right that when one considers our submissions at paragraphs 10 through to paragraphs 21 of our case statement, those points I doubt are an issue, and if they are, in my respectful submission, they probably don't take the matter too far. But moving to the decision on the merits, my Lord, that's found at paragraph 22 of our case statement, and it is that particular, it's at that point that I would invite Mr. Curl to address my Lordships, who will present, make submissions in respect of the decision on the merits and touch on the actual underlying complaint, although of course we have addressed that so far. So with my Lord's leave, I will invite Mr. Curl.
Yes, thank you, Mr. Curl.
May it please your Lordships, my submissions will concern cause of action estoppel, and in particular I will seek to show your Lordships that the dismissal of the conviction complaint was a dismissal on the merits of that complaint. Now, this is important because if I'm successful in showing you that the conviction complaint and the conduct complaint were the same and that the conviction complaint was disposed of on the merits, then a cause of action estoppel arises, which is an absolute bar. Now, it's common ground as between the parties that there's no need for the complaints to be exactly the same. What matters is a question of substance, and I reiterate that's common ground between the parties. It's, of course, right that that's so, because if it wasn't so, then, of course, cause of action estoppels would very seldom arise, because parties will always make an attempt, at least, to make the complaints look superficially different. So it's a question of substance. Spencer, Bauer and Handley put it like this. It's whether the first proceedings determine a question raised in the later proceedings. So what's not common ground between the parties is what the question was that was determined in the conviction complaint.
Have you got the reference to Spencer Bauer?
Yes, indeed, my lord. It is...
Well, the page reference.
Yes, I can have one moment, my lord. The page ref is at paragraph 1.02 in Spencer, Bauer and Handley.
Where is it in the bundle?
Tab 83.
Yes, it's tab 83, my lord. Those are the elements.
Is that volume 9, is it? Yes, it is. Volume 9.
Those are the elements that my learned friend Mr. Jones read out a few minutes ago. It's the fifth of the 6 ingredients.
So, which paragraph?
It's paragraph 1.02, my lord.
You're not distinguishing between cause of action estoppel and issue estoppel for this purpose.
My lord, the principles of res judicata are the same. Cause of action estoppel and issue estoppel are different. This case is a cause of action estoppel, yes, my lord. An issue estoppel doesn't arise.
No, because you've been sliding into the language of issue estoppel, that's why I asked.
My lord, yes, the language of res judicata is in my submission universal, whether it's cause or issue. I'm very clear, my lord, that this is cause of action estoppel, not issue estoppel. So, my lords, what's not common ground?
Is the idea of cause of action an appropriate expression in the context of disciplinary proceedings?
My lord, yes. There's no difference of principle between the way the cause of action is framed in disciplinary proceedings and any other proceedings in my respectful submission, my lord. The cause of action, as Mr. Jones has highlighted, arises under bylaw 4.1a. There's no freestanding cause of action that arises under bylaw 7.1. That's purely an evidential provision, as I will come on to in a moment. But the cause of action is whether or not there's been an act or default, such as to bring discredit on the member, the institute or the profession of accountancy in 4.1a. That's the cause of action.
Yeah, that's why it's misleading to talk about a conviction complaint.
Well, precisely so. It's simply a matter of convenience to put a convenient label on there. I think in the first proceedings we called it the first complaint, but it's somehow over the course of time become known as the conviction complaint. But I would urge your lordship not to draw any conclusions from that. So we say, my lord, that in both complaints, the question, for the purpose of the question determined, the question in both complaints was the breach of the Jersey direction in December 2002. So it was failing to comply with the Jersey direction in December 2002. That's the breach, that's the question. Now, my lords, in my submission, the answer to this question can be found in the Institute's bylaws, and I may be repeating a little of what Mr. Jones has said, but you must stop me, my lords, if you've heard enough. Both complaints, of course, are brought under bylaw 4.1a, which, as the Institute puts it in their case, is the umbrella provision. Naturally, 4.1a doesn't specify the identity of the act or default, because, of course, to assemble an exhaustive list of acts or defaults of misconduct would be an impossible exercise. pausing here, it's important to note, and I would urge your lordships to note, that the bylaws do not make being convicted a freestanding cause of disciplinary action. In that respect, these bylaws differ from the disciplinary rules of other professional regulators. And as Mr. Jones has already pointed out to your lordships, Mr. Justice Owen recognised this point at paragraph 33 of his judgment. So instead, the Institute prefers to have this general umbrella provision. Now, plainly, as we've already been through, my lordships, your lordships, a conviction cannot of itself sensibly be regarded as an act or default on the part of the person convicted. And I think that must now be settled. And indeed, the Institute's taken no issue with the authorities that I've brought forward to show that an act or default cannot be a conviction. For an act, someone must do something. For a default, someone must fail to do something he should have done. Now, my lords, the reason I've gone over those points again, which Mr. Jones has already ventilated, is because I submit to your lordships that for the Institute to succeed today before your lordships, they must show that a conviction is capable of itself of being an act or default on the part of the person convicted. And I respectfully submit that this they cannot do.
I thought we were on a different point, namely whether or not this was a decision on the merits.
Well, indeed, my lord, and I'm coming on to that, but these issues are all bundled up together somewhat, and
I shall proceed on the basis you've got a fair wind on the first point and get on to the second.
I'm most grateful. The reason...
Lord, can I make it clear I should be trying to blow your lordships in a different direction? I mean, my learned friends have not aptly characterised what's in issue here, and certainly much that has been said is disputed, but I'm not going to intervene now, just to clarify that those will be issues, two issues: one, same cause of action; two, decision on merits, as far as res judicata is concerned.
My lords, the reason this is the actual default point is significant is for this reason, and it does go directly to merits. If the act or default is not the conviction, and as your lordship has indicated, we seem to be there on that. If the act or default is not the conviction, then the act or default must be something other than the conviction. What is that something else? Now, in my submission, that something else can only be the conduct on which that conviction is based. My lord, the reason we lost on cause of action estoppel before Mr. Justice Owen was for the reason that Mr. Justice Owen considered that the fact that the act or default was unspecified in the conviction complaint meant that it was different from the conduct complaint, because in the conduct complaint the act or default was specified. That's where we lost on cause of action estoppel at first instance before Mr. Justice Owen. I submit to your lordships that whether the act or default is specified or unspecified, the point is that it's there, and specified or not, it must be the same. If the act or default is not the conduct underlying the conviction, then there is simply no other candidate for that act or default. We've established the act or default is not the conviction itself. It's something beyond the conviction. What is it? I respectfully submit to your lordships that it's the conduct on which that conviction is based.
Well, you have to look at the complaint itself, and I suppose you're saying it's paragraph 8, is it?
Well, indeed, my lord, both the face of the conviction and as a matter of language and logic. If there's an act or default, what is it? We've established it's not the conviction, it's something else. It must be the conduct which is failing to comply with the Jersey direction.
But are you doing this by way of inference or by looking at the document to see what it says?
My lord, the face of the conviction complaint does say that it's failing to comply with the Jersey direction. But I am also, my lord, and I make no apology for it, drawing an inference, simply as a matter of logic. What must the act or default be? It's failing to comply with the Jersey direction.
Well, I'm still not clear. I mean, for myself, I'd like to be taken again to the, what you call the conviction complaint, to be told what it is in there of which complaint is actually being made on your case, which is the same as in the second.
My Lord, turning to page 85 at tab 9, which is what has become known as the conviction complaint, we see there the defendant is liable to disciplinary action under 4.1a, and then it just simply recites 4.1a. That's the cause of action. And then the complaint is particularised in the following sentence. And we have there, was convicted upon indictment at the Royal Court of Jersey on the 16th of September 2003 of failing to comply with the direction issued on 18th of December 2002 by the Jersey regulator, and so on. And my Lord, my respectful submission to your Lordship is that we've established that a conviction cannot be an act or default. So the first half of the first sentence, or the first half of the complaint really, up to 16th September 2003.
But you have to look at the document as a whole, don't you? And you may well be right on this, but if you look at the document as a whole, I think, isn't your case that if you take paragraphs 8 and 14 together, there is a complaint of discreditable conduct?
My Lord, we say that the complaint taken as a whole is in substance the same as both complaints.
Yes, but what is it?
What is it? It's failing to comply with the Jersey direction. That is the act of discreditable conduct. Your regulator gives you a direction, you fail to comply with it. The first few words of the particulars of the complaint, was convicted upon indictment, cannot be an act or default. So that is simply setting out some of the evidence, or the piece of evidence that the institution tends to rely upon. It doesn't set out the act or default, because a conviction cannot be an act or default. So the act or default is failing to comply with the direction.
Yes, I mean, you could say that the conviction is an irrelevant averment.
One could indeed say that, my Lord. It's not for us to tell the Institute how to refer its complaints, but indeed, yes, it would have been far simpler if the Institute had simply said in that he failed to comply with the direction issued by the JFSC. And had they done that, they could have brought forward evidence based on Bylaw 7.1, evidence based on Bylaw 7.3b, and also the whole raft of witness statements that already existed at the time the conviction complaint was brought.
I don't know whether the conviction itself would be a finding of fact within the meaning of subsection of 7.3, would it?
The conviction itself is conclusive evidence under 7.1.
I wasn't asking you about that. I was asking whether or not it could be a finding of fact under 7.3.
Well, my Lord, I say it could. Not the mere fact that he was convicted, but the particulars of the conviction. If one considers the face of the Jersey conviction, it says he failed to comply with, and so on. So the conviction, if it's nothing else, the one thing it must be is a finding of fact that he did breach the direction. That is the very matter that the Royal Court of Jersey had to determine. So in my respectful submission to your Lordship, the finding of fact of the Royal Court was that Mr. Coke-Wallis had breached the direction. So in my submission, and I was going to come on to this a little later, but we'll address it now. In my submission, it would have been quite open to Miss Pito, the advocate at the hearing of the conviction complaint, to have said, well, very well, Mr. Chairman, I can see, because pausing there, the Chairman gave her plenty of notice that he wasn't satisfied if one considers the transcript. Miss Pito could have said, well, Mr. Chairman, I can see that I haven't satisfied you on 7.1, so perhaps I could invite you to turn to Bylaw 7.3b. Under Bylaw 7.3b, you can take any finding of fact by a court of competent jurisdiction as prima facie evidence of those facts found. Now, look at this. Mr. Coke-Wallis's conviction says that he was convicted of failing to comply with the Jersey direction. That's not the sort of conduct that should be expected of a member of this institute, and I would invite you to conclude that that's prima facie evidence that he did it. That finding of fact that he did breach the direction. And without more, Mr. Chairman, you may conclude on 7.3b that that prima facie evidence satisfies you, and you may therefore find that he did commit an act or default of misconduct under 4.1a. So my respectful submission to your lordship is that, yes, they could have got home under 7.3b, even on the wording of the conviction complaint. And it's very, I would urge your lordships to be alive to this
This
point.
makes your case particularly technical, though, doesn't it? Because it means on that very day they could have said precisely that.
Well, they could have done, but the crucial point is, my lord, they didn't. They didn't. And my client must not suffer because the Institute either prepare the complaints wrongly or don't understand their own bylaws. If I'm right that that point was available, it was available.
So what was the point? How was it available exactly?
I'm sorry, my lord?
How was it available exactly?
How is it available exactly?
Yes.
Well, the face of the conviction complaint, even as drafted, says he was convicted upon indictment at the Royal Court of Jersey on 16th September 2003 of failing to comply with the direction.
Yeah.
7.3b allows any finding of fact by a court of competent jurisdiction, of which the Royal Court is one, to be taken as prima facie evidence of the facts found. Now, my lord, my submission on this point is that a conviction is a finding of fact
Is it?
that the
Is that
defendant
right?
did it.
Is that right?
Well, my lord, I respectfully submit, what else could it be?
Well, it could be a conviction.
Well, it's a conviction that the person did it. The idea that a finding of guilt is not a conclusion that the person did it is in my submission, not a well-founded one.
Well, I mean, I don't know. I mean, have we got a record of what? I mean, it's just you're just saying that you just look at the conviction. That's all.
Right. The conviction isn't in evidence, although I do have a copy with me, so I can hand up a copy. Although it simply says he failed to comply with the direction. My lord, would you like to see a copy of the conviction?
I'm just trying to understand exactly the terms of the argument.
I'm not pressing this as our one and only killer point. It's simply a point that shows to use autrefois language, that Mr. Coke-Wallis was in jeopardy and he was in peril, and to use cause of action estoppel language to show that the decision was on the merits.
I mean, your primary point is that the Institute chose to put all its eggs in one basket. And I haven't looked at all the correspondence that preceded the hearing, but your client, as I understand it, correctly understood that the only way the case was being put against him at that hearing was going to be that he'd been convicted of an offence which was had an equivalent in England and Wales.
My lord, yes.
And he could justifiably have complained, could he not, if he had been convicted without any warning on the alternative basis that you're putting forward, a prima facie evidence.
He perhaps could have done.
Yes.
We're now getting into the realms of quite serious counterfactual debates, but
yes.
he perhaps could have done. And indeed, if one looks at his written submissions that he put in, albeit asking for an adjournment, but he went at this complaint on the merits, on his written submissions, which your lordships have seen as part of our what we've called the Appendix Part 3 documents. And he did say this simply wouldn't be regarded as criminal. But what I say to your lordships is that whether one sees it as the Institute wrongly drafted the complaint too tightly in fettering itself to bylaw 7.1, or whether we can justifiably say that the bylaw wrongly failed to realise that 7.3b was available to it on the drafting of the conviction complaint, whichever way we put it, if the Institute was fettered, it was a self-imposed fettering, either by the way it chose to draft the complaint or by the way its advocate chose to argue it on the day. If its hands were tied, it tied its own hands.
Well, if you look at the complaint, which is tab 9, as far as I can see, the first two lines of the after "in that he" are an irrelevant averment because they're not part of the particulars. But if you look at the summary of the complaint, where they allege they rely upon the convictions, then assuming that a conviction is or is capable of being evidence of the facts contained in it, if you like, then those are relevant. That's relevant evidence under Article or Paragraph 7.3b. So all that would have been admissible. But you say they chose not to advance it on that footing. They chose to advance it on a 7.1 basis only.
My Lord,
That's what happened.
My Lord,
That's the basis upon which it was decided, and you say there you have your res judicator, or however you put it.
Well, my Lord, yes, although I don't say that all the words after in that he are irrelevant. I say that
No, only
is,
down to the 16th September 2003.
Well, those first 10 or so words,
Yeah.
yes, are irrelevant, because that's simply the Institute, because it's habitual practice, putting in effectively the evidential device that they propose to use. It's alluding to bylaw 7.1, although it's not obvious to a layperson or even a lawyer who doesn't have the bylaws in front of him or her that it's referring to 7.1, but that's what the Institute say. And the Institute will say that they could only look at 7.1, and that was the only point before the tribunal, was whether there was this corresponding offence. And I repeat that if their hands were tied, they tied their own hands in choosing to frame the complaint that way. Now, my Lords, if I might return to my discussion of the point Mr. Justice Owen made at first instance about the reason we lost on cause of action estoppel at first instance, it was because, in Mr. Justice Owen's view, in the conviction complaint, the act or default was unspecified, whereas in the conduct complaint, the act or defaults were specified. Now,
Can you just show us that, please?
yes, of course, my Lord. It's at tab 4 of the appendix. And it's at paragraph 31, which is page 25. And Mr. Justice Owen says, the flaw in Mr. Jones' analysis is that 7.1 is not used to prove the specific facts giving rise to the conviction. Rather, the fact that there have been acts or defaults, unspecified, that resulted in conviction. A fine distinction, but in my judgment, nevertheless real.
Sorry, where were you reading from?
That's the last sentence of paragraph 31 of Mr. Justice Owen's decision.
Thank you.
Now, where I'm going with this, my Lords, is that, in my respectful submission, it doesn't matter whether the acts or defaults were specified. If the acts or defaults were real, sufficient to ground a finding of misconduct under bylaw 4.1a, then they existed somewhere, specified or not, and they had a real objective identity. They weren't somehow hovering in the ether, but they were real, specified or not.
But why weren't they specified in detail under summary of the complaint?
Well, you would say they were.
I mean, but how does the judge conclude that they weren't, when there seem to be many paragraphs of allegations?
Mr. Justice Owen was looking only at the words after in that he, because
and what was his excuse for that? And what was his reason for that? Sorry.
Because those are the particulars of the complaint. My Lords, I'm not appearing before you to argue in favour of Mr. Justice Owen's. He got it right.
No,
my point is that putting the best possible spin on this for the Institute, specified or not, the acts or defaults are the same, and the only candidate for them is the conduct. Now, I have authority that shows that my analysis is the right one, and that it doesn't matter whether the breaches are specified, because the breaches are the same specified or not. And that's the authority of Workington Harbour, which is at tab 65 of the bundle. Now, my Lords, very briefly, the facts of that case.
So what Mr. Justice Owen holds is that you don't need to, that it's enough to show that the person has been guilty of an offence which is something which would be discreditable conduct, but you don't actually need to prove what the discreditable conduct was.
Precisely, that's what Mr. Justice Owen says, yes.
I do have difficulty with that proposition. If it were right, then there could have been a second set of disciplinary proceedings on basis. Now, this is something quite different. This is not just a conviction for.
Well, precisely so, my Lord. Precisely so.
Yes.
If Mr. Justice Owen was correct, then the fact that the the actual default, the offence, if you like, isn't fully specified, but merely the evidence used to prove that there has been some nebulous, unspecified actual default is sufficient to make it different. But I submit to your lordships that the actual default, specified or not, is the same.
Yes.
And it's the conduct. It can only be the conduct. That's the only thing it can possibly be.
And of course, he brings it back in because it said it then would be relevant to the action to be taken by the disciplinary committee.
Well, yes, and there's some further points I wish to make about the distinction between culpability and mitigation, which we'll come on to.
But what I don't understand is, I just don't understand, has he said that everything after, everything other than the 4 lines at the bottom of page 85 is irrelevant? And how did he reach that conclusion?
Yes, well,
why do you disregard the other, say, 15 paragraphs?
I'm not absolutely certain, my lord. My lord, if I could refer to Workington Harbour. It's at tab 65 of the bundles. Now, I don't need to go into the facts in a huge amount of detail, but...
Volume 7.
In Workington Harbour, the defendants provided a bond to guarantee the completion of some building works. And in the first Workington proceedings, an engineer's certificate was relied upon as conclusive proof, note those words, my lords, conclusive proof of certain breaches. They didn't particularise the breaches in the first set of proceedings. Now, those proceedings failed because the engineer's certificate didn't do the probative work that the plaintiffs hoped it would do. But undeterred, they brought a second set of proceedings, and in this second set of proceedings, they did particularise the breaches. But the House of Lords held that the dismissal of the first set of proceedings gave rise to a strict res judicata. That was despite the fact that the breaches were unparticularised in the first set of proceedings, but particularised in the second. Now, in my respectful submission to your lordships, that's precisely what happened here. The engineer's certificate on the one hand and the conviction on the other were both held up by the pursuers in both cases as being conclusive evidence of certain things beyond themselves. In the engineer's certificate case, it was the breaches of contract, and in this case, it was the conduct underlying the conviction. That's exactly this case. Now, coming back to the on the merits point, which is the main theme here, this, in my submission, is where the Institute runs into difficulties in its run of cases from Haynes and Davis, where it relies on the cases of De Bardi. Now, in the case of De Bardi, there was a mistake in the way the particulars of an offence had been drafted. It wrongly said that the defendant had paid a cheque to himself when it should have said that he had paid it to cash. But the distinction is that in De Bardi, the prosecution realised its error and offered no evidence. And in Williams and DPP, which is a similar sort of case, this was the case about the offence was wrongly particularised as being reliant on a breath sample, when in fact a blood sample had subsequently been taken, which rendered the breath sample inadmissible. But that's it. The evidence in Williams was inadmissible. And in Jelson and Harvey, the fact that a notice of motion did not comply with the relevant RSC order was spotted, and the judge did not look at the evidence, and no order was made on the motion. So, in my submission, De Bardi, Williams and Jelson are not like Workington Harbour, and crucially, my lords, they're not like this case, because in both Workington Harbour and in this case, the conviction, or the engineer's certificate, was admissible, and it was carefully considered, and we have the transcript of our case to show that there was a great deal of cut and thrust between the Institute's advocate and the legal assessor of the tribunal. There were also written submissions from Mr. Coke-Wallis. So it's nothing like...
Why isn't it like the breath case?
It's not like the breath case because that evidence was inadmissible under statute, whereas in our case, the conviction was admitted as evidence. It was admitted as evidence, but it didn't do the probative work. that the Institute hoped it would do. You see, and if we say that our case is not a dismissal on the merits, then, well, we can say that...
That's because of Rule 73B, is it? If there were no Rule 73B, it would be the same, would it?
No, Rule 7.1 says that a conviction that corresponds is conclusive evidence.
If it's a relevant conviction, but this wasn't a relevant conviction, and therefore it wasn't. Therefore
Lord,
it was inadmissible.
No, my lord, it's admissible, but it just doesn't do the probative work that the pursuer hopes it will do.
You say that what they set out to do was to prove the conduct complained of.
Yes.
They set out to do it by one way only,
Yes.
which was relying on a conviction. That didn't work, ergo they failed to prove what they set out to prove, and there was a final decision against them.
Precisely.
That's
That's exactly my case.
And the difference between that and the breath case?
The breath case, the evidence was inadmissible as a matter of statute. It couldn't be considered. In this case, the conviction was admitted and considered. There's a distinction between evidence that goes in but doesn't come up.
That seems a very, very narrow distinction to me.
What if... Sorry, carry on.
If I could make one
Yes,
further,
you should, please.
One further submission on the breath case. The reason the breath wasn't admissible was because there was a blood sample taken afterwards, and a blood sample means that you don't look at the breath, you just look at the blood. So it was a simple administrative confusion. Oh, we should have said blood, and we mistakenly said breath. And in my submission, my lord, if my characterisation of the distinction between admissible and inadmissible is wrong, then in every case where evidence is admitted, considered, but doesn't do the probative work that the prosecutor hopes it will do, in every case one can say there isn't a disposal on the merits. And in my respectful submission, my lord, that would be absurd. This evidence went in.
If you look, what I understand Mr. Justice Owen to be saying in that passage we're looking at, if you look at 7.1, isn't he saying, if one looks carefully at 7.1, it's the fact that somebody has been convicted of an indictable offence is itself conclusive evidence of the commission of an act of default for the purposes of bylaw 4. So you don't need to look into anything behind it. It doesn't matter, because that tells you, if you just hand it up, that's it.
That's right, my lord. The clue there is that he says conclusive evidence of the commission.
Such an act or default.
Of such an act or default. So that's right, it proves that they have committed an act or default. But we've already established, my lord, that a conviction cannot of itself be the act or default. No. So what is the act or default? Mr. Justice Owen said there are act or defaults unspecified, but nonetheless real. Yes, so what is the act or default? In my submission, the only candidate for the act or default is the conduct underlying the conviction. There is nothing else that act or default can possibly be. My lord, what else could it be? It's either the conviction or the conduct. There's nothing else there.
You accept that Williams was correctly decided, the breath test case, do you?
Williams was...
Where is Williams in the bundle?
64 in volume 7.
My lord, I don't say that it wasn't wrongly decided, rightly decided. I do urge your lordships to draw the distinction between admissible and inadmissible, and that is how we get away from Williams. Now, my lords, if there remains any doubt at all that the act or default is the conduct, then in my submission it's resolved by looking at the way the Institute prosecutes other cases under bylaw 4.1a where there have been previous court proceedings. And I set out at tabs 67, 68 and 69 3 recent cases.
So I just like to go back to Williams. What actually happened in Williams? Was Was the breath, the evidence of the breath tendered in evidence, or did it never get to that?
It was inadmissible.
Well, never mind about that. What had actually happened procedurally?
I,
64, yes.
I will need to turn to the case, my lords. At the hearing of the information, but before the defendant had admitted a plea, his solicitor submitted that a conviction was not possible. The justices dismissed the summons, and a fresh summons was issued. So there was never even a plea on it, let alone a disposal on the merits.
Look under the hill. This is helpful. Yeah. You may want to read it.
It says that a defendant could not be in peril of conviction before the plea was taken.
As a matter of law, incapable of being proved, which is this case. So
Yes, so it says as a matter of law, it's incapable of being proved, whereas we say that as a matter of the
But the issue was whether the defendant was ever in jeopardy, wasn't it? Wasn't that the issue? See page 1165 at E.
Yes, so it's both because the evidence is inadmissible and also because it goes before he's even pleaded to it. So as a matter of law, he can't possibly ever be in
But
jeopardy.
is it not just a jeopardy case?
I'm sorry, my lord?
Is it not just a jeopardy case? That's to say that the judge held that the argument was that he'd never been in jeopardy.
Yes.
Yes.
Whereas we say Mr. Coke-Wallis was in jeopardy because there was this discussion about whether the conviction did the probative work that it was meant to do. And this discussion went on both before the hearing, in the correspondence that your lordships have seen in Appendix Part 3, and at the hearing itself, where there was the discussion, the back and forth between Miss Petto and the chairman and the legal assessor of the tribunal. And that's quite different from a situation where the charge goes before a plea is even entered. So a parallel exists between the situation in Williams and the situation in our case. We say that had the error been spotted, or when the error was spotted, because of course the legal assessor spotted the error, when the error was spotted, Miss Petto, the advocate, should have said, well, Mr. Chairman, that's possibly an error that we have made. I would respectfully ask for an adjournment. We'd like to take this complaint away and refer it back to the investigating committee and ask the investigating committee either to prefer a new complaint, and we'll withdraw this one before there's been any disposal of it, or we will amend this one. And
Is there any reason of policy why there should be such a difference between the two situations?
Yes, it's peril of conviction. If the matter proceeds to a reasoned disposal on the merits, if it proceeds to the point where it's dismissed, then that is the disposal. And there is a very good reason of policy why people can't be put in jeopardy twice. And it matters not whether that disposal is a correct disposal or an incorrect disposal. Right or wrong, there can only be one adjudication on the merits. And it's up to the prosecutor how they choose to frame those merits. And it got dismissed.
And I'd say, looking at the judgment of Mr. Justice Rougier, one certainly gets the impression that had the defendant not taken the point before he was charged, but been charged and pleaded not guilty and then taken the point, his plea of autrefois acquit would have succeeded.
Well, my lord, I'm most grateful for that. That is essentially the point that I've been trying to make.
Yes. Well, that's perhaps reading it quickly. That's dealing with the first contention.
Well,
Now, my lords,
It's the qualitative
Prosecution is
question.
bound to fail, is the other one.
Second.
That seems very much more questionable. So you're accepting the qualitative point, are you? I mean, it's one thing to say you never got to the stage where the defendant was in jeopardy because he hadn't pleaded. It's another thing to have some kind of analysis of what, which Mr. Justice Rougier goes in for at page 1170 at F to G.
well, my lord, the qualitative point is satisfied because what was the act or default? It was the conduct. That's what the conviction was trying to prove. Conviction was proving something beyond the conviction, and that was the conduct. So the dismissal of the conviction complaint was a dismissal of a complaint based on the conduct. Now, the Institute chose to frame its complaint in the way it did, and nonetheless, its dismissal is a qualitative dismissal of the conduct as well as the conviction. Now, my lords, if there is any residual doubt that that's the approach the Institute takes, it's settled by looking at the authorities at tabs 67, 68 and 69, which, this is in bundle 7, and these have been selected because they're each recent cases. The case at 67 is based on bylaw 7.1. They use 7.1 to prove the misconduct. At 68, they use 7.3b to prove the misconduct. And at 69, the member admitted the actual default of misconduct, although in my submission that the approach to that case would have been much the same if it had been based on other external evidence. And if one considers the approach taken by the tribunal in those really very short case reports, but the matter that is before the tribunal, the thing that the tribunal thinks is being disposed of, the matter before it, is in each case the conduct. The conviction simply proves what's gone on, and indeed in the case at tab 68, it's not a conviction at all, it's simply findings of fact in a civil court. But nonetheless, the approach taken, whether 7.1 or whether 7.3b, is the same. We're talking about proving acts of conduct, and I would urge your lordships to reread those cases at 67, 68 and 69 when deliberating, because this shows what it is that the disciplinary tribunal is looking at. Now, the Institute, in its written case, has responded to these cases by pointing out that culpability and mitigation are different things and they're analytically distinct. And that when the tribunal looks at the underlying conduct, that goes only to mitigation. That's the Institute's point on this, and I take no issue with the point the Institute made on this. I accept it as far as it goes. But I submit that it doesn't help the Institute to draw that distinction, because the point is that if the conduct underlying the conviction is relevant to mitigation, and the Institute say that it is, if the underlying conduct is relevant to mitigation, then the underlying conduct must be the subject matter of the complaint. Because if it were otherwise, referring to it in mitigation couldn't possibly mitigate the complaint before the tribunal, if that wasn't what the tribunal was looking at. And my lords, I should like to turn now to a point which has been alluded to by the Institute at various times.
Yes, just before you do, I've now read the whole of Williams, and it does appear that the defendant lost on both points. First of all, the temporal point hadn't yet reached the stage of being in jeopardy because he'd never pleaded to the charge. And second point, he'd never been in jeopardy because the prosecution had mistakenly relied upon the breath sample rather than the blood sample, and therefore he was never in jeopardy of being convicted.
Well, a clue there, of course, is mistaken reliance, and in this case, it wasn't a mistaken reliance, it was an advertent decision that was taken to press on with the conviction on the basis that it was equivalent, because the Institute took the view that DC Grieve was correct, that DC Grieve's construction of the bylaws was right, and that they would be able to get this home. And Mr. Coke-Wallis took a different view. Mr. Coke-Wallis took the view that what he had done in Jersey would not be regarded as criminal in England. And of course,
But speaking by itself,
Yes.
it appears to me that the sentence which reads, assuming as one is entitled to do, that the matter had ultimately been deciding according to correct legal principles, the defendant could never have been convicted, is an extraordinarily broad statement, which, to my mind at least, doesn't sound right.
well, in my submission, it cannot be right, my lord, because
Well, I thought you were accepting Mr. Justice Rougier's analysis.
well, I was accepting that that case was rightly decided. I'm not saying that that particular things said in particular cases are said with reference to the facts that were before the court on that occasion. And that, as a general principle, I would respectfully submit is not appropriate to extrapolate to every single piece of litigation before the courts. Because if it is, what one can always tell after the court has decided something, one can always say, yes, well, that's the correct legal principle that the court applied.
I think what you're
to those
saying
facts.
is that the case was correctly decided on the first point, but that the second point was not correct. Seems to be what you're saying.
My lord, yes.
You should be saying, Fabian might be saying that.
There might be some force in that.
Is there anything in Spencer Bauer on the, where they discuss what's meant by the merits?
The answer is very little, as far as I
Yeah.
can see. It's tab 83, and if I've got the right place, it's page 89 of the res judicata. It's the last part of it, anyway. Page 89, chapter 6.
Tab 83, first page. Oh, sorry, no.
It's actually about halfway through
You go to
the
to
extract.
chapter 6. It's quite near the beginning, actually.
Volume 9, 683.
I mean, I'm not sure, for example, at bottom of page 89, dismissal of an action for criminal conversation because the cause of action was not known to the law of Hong Kong was a decision on the merits. I don't know how that would stand with Mr. Justice Rougier.
Because it establishes the merits on the basis of the merits as they are before the court. It's up to the prosecutor how the merits are framed. And if the subject matter of the complaint is the same, then it matters not how the prosecutor has chosen to bring it forward, as long as it goes to this qualitative aspect and this temporal aspect. As long as it gets to that stage and it's dismissed or found proved, then that is a dismissal on the merits. And my lords, this might be an appropriate time to go on to whether the decision is right or wrong, which is irrelevant. And there's plenty of authority to say that whether the first proceedings are decided rightly or wrongly, stepping back and looking at it, is not relevant. And we go into quite a lot of detail on that in our written case at paragraphs 84 to 85. But a couple of points I should like to highlight. Lord Millett gives the best analysis of the right or wrong point when he says in Mulkerins and PricewaterhouseCoopers, the doctrine comes into its own only when the decision is wrong. If it's right, it merely serves to save time and costs. And in my submission, this is what res judicata is for. There's got to be an end to litigation. And this is particularly important in disciplinary tribunals. Arguably as important, if not more so, in disciplinary tribunals than elsewhere, because otherwise there would be no point in having these quasi-judicial tribunals. If a pursuer like the Institute got a result it didn't like and just wanted to go again, either for any reason, it would be oppressive, and this case is oppressive. It's in Workington Harbour, which is really this case in my submission. Lord Atkins said that the result is that the plaintiffs, who appear to have had a good cause of action for a considerable sum of money, failed to obtain it, and on what may appear to be technical grounds. Reluctant, however, as a judge may be to fail to give effect to substantial merits, he has to keep in mind principles established for the protection of litigants from oppressive proceedings. My lords, that is this case. It matters not that the Institute now wish that they had prepared differently, and it matters not that the Institute perhaps now wish they'd paid a bit more attention to Mr. Coke-Wallis's correspondence, which has been now put in as Appendix Part 3. That doesn't help them. Now, my lords, in Workington Harbour, it was clear that superficial differences don't mean the matters are not the same. And although Workington Harbour is the most on-point authority, there are plenty of others like it, of the highest authority. And in Trawl and Effin Foods, which is at tab 78, Australia's highest court found that a second set of proceedings were subject to the strict res judicata bar, even though negligence was not alleged in the first set of proceedings, but was alleged in the second set. So on the face of it, that looks really quite different.
You're going a little bit fast, but you shouldn't assume that we've read all these cases.
Very well, my lord. This is at tab 78.
I wonder if we just go back to
Yes.
Workington, because obviously Workington is, from your point of view, a very important case. Could you just show us the passage you read out a moment ago?
My lord, yes. That passage is at tab 65, and it goes over pages 105 and 106. I'm sorry, that particular quote is actually at DE on 106. Starts halfway through a line. And another important finding by the House of Lords in that case, at F, it says, the plaintiffs chose, and in view of the complexity and expense relating to the various alleged breaches, no one can call them unreasonable. And perhaps the Institute would like to say that that applies to them, although given the Appendix 3 documents, I'm not so sure. But nonetheless, that shows that this isn't an excuse. They chose to take the risk and to adhere to the certificate as the only necessary proof. They failed, and the consequence is inevitable. And also in that last paragraph of Lord Atkins' decision, it also says that this is a strict res judicata, and so there's no need to go on to consider the further objection, which, although he doesn't use the language, he's talking about abuse of process. So there's no need. That's not an abuse of process case, that's a res judicata, strict bar case, even though the breaches are unspecified in the first set of proceedings. Now, my lords, the Trawl and Effin case, which is at tab 78, in that case, I'm looking at page 422, my lords. In that case, the two sets of proceedings were on their face different, and there had been great efforts to make them look different. Indeed, negligence wasn't even suggested in the first proceedings, or not particularised in the first proceedings. But nonetheless, Mr. Justice Gummow, in the Federal Court, which was upheld by the High Court, said, in my view, Epham has made out its case of cause of action estoppel against Trawl. This is so even though no claim previously was made in negligence.
Which page are you reading from, please?
My Lord, this is page
422.
422.
Thank you.
The substance of the controversy embraces such a claim. Now, in my submission, that's analogous to this case, because in the conviction complaint, the substance of the conviction complaint embraced the controversy of the conduct complaint, because the conduct was the act or default. Unspecified, perhaps, yes, but nonetheless there.
So you're going back to cause of action, not you're no longer on the merits.
It's cause of action estoppel.
Yes,
my
yes,
Lord.
I know.
On the merits is an ingredient for cause of action estoppel, my Lord.
Yeah, of course, but this case is not about on the merits, is it?
But my submissions here are that whether the decision is right or wrong is irrelevant.
You've moved on from on the merits to the right or wrong point.
This is now right or wrong, my Lord. My Lords,
I went to those.
My Lords, the case of Conquer and Boot was the same, even more striking in
Well,
that
if it's going to be striking, could you just tell us where it is then?
my Lord, it's at tab 6.
Thank you.
Now, is this rightness-wrongness point in dispute?
My Lord, the Institute has made references, and Mr. Beloff's made reference today to the point of the second proceedings when the point arose about if there had been if the conviction complaint had been found proved, Mr. Beloff wouldn't have said that the Institute could go after Mr. Coke-Wallis a second time, and Mr. Beloff said that there would be no point. Well, that suggests that there is some relevance to the right or wrong point, and that the Institute is saying that because Mr. Coke-Wallis, they didn't get him the first time, they want another chance to get him. And in my submission, that flies in the face of all authority. The point is that they had one long bite of the cherry, and they're not allowed to have another one. But my interpretation of the Institute's position is that the rightness-wrongness point is in dispute. So at tab 6, we have Conquer and Boot, which is a claim, although both claims were for breach.
I'm not quite sure what we mean by right or wrong, because it might have been the case that the tribunal were wrong in deciding there was no equivalent indictable offence in England and Wales.
They appeal. Well, they
I would have thought maybe that's what's meant by saying it doesn't make any difference whether the tribunal is right or wrong. And just imagine that there is an equivalent indictable offence in England and Wales.
Well, then the Institute should have been ready to take the tribunal to it. It doesn't matter.
The tribunal got it wrong, but that's you would say, so much the better for my client. There might be some appellate jurisdiction, but what he can't be subjected to is another trial, even if he has had an unmeritorious win the first time round.
That's exactly our position, my Lord. In the Senate, that very point is made by Lord Brandon, which is at tab 58, at 501. Lord Brandon held that the appellants elected to have one good long bite at the cherry before the Dutch courts. They lost before those courts, and they lost on a technical reason, that there was an exclusive jurisdiction clause for the Sudanese courts. and it was concluded that there is no possible justification for allowing them to harass the respondents by taking a further long bite of the same cherry in the action which they have brought here.
That's a very tactful authority to refer to.
It's a bit wrong.
That's at tab 58, my lords, on page 501.
Oh, yes.
It's almost the last thing in the judgment. So it was a technical reason why they couldn't go ahead in the Dutch courts. They hoped to go ahead in the Dutch courts, but they couldn't because of this Sudanese jurisdiction clause. And so they decided they wanted to have another go in England. And my lords, that's precisely...
Well, I suppose it depends which side you're on, whether that's a technical point or not. The Sudanese jurisdiction clause point.
Well, it's in my submission, my lord. It's technical if our case is a technical dismissal. I don't accept that it is. But it's on the merits as the merits are framed by the Institute, and even if it was a legalistic point of construction of the Institute's bylaws, that doesn't stop the disposal being on the merits. And that's why in the Senna, they couldn't have another go. And in my submission, the language there about one good long bite of the cherry before the Dutch courts, and they lost, there's no justification for allowing them to harass the respondents by taking a further long bite of the same cherry in the action which they have brought in the Admiralty Court here, is, in my submission, that is precisely analogous and appropriate language for this situation. They had a long bite of the cherry, going at Mr. Coke-Wallis, trying to use his conviction as conclusive evidence, and they failed in that. They took a reasoned, considered decision to go after him on the basis of the conviction, and it was a reasoned, thoughtful decision, and it was dismissed because they hadn't done their work properly. And on that basis, they shouldn't be permitted to have another go by putting the complaint together in a different way. And that is Workington Harbour, and that is the Senate. And so in my submission, this disposal was on the merits. Now, my lords, I know that your lordships are keen to hear about them. Those are the submissions I have on the merits, and if your lordships have further points you would wish to raise on the merits, I would invite your lordships to do so, and I will ask them as best I can, but those are the submissions that I have prepared on the merits.
Thank you, and if we do have further points to raise, we shall do so at 2 o'clock.
Motion open, my